Hello, everyone. Good afternoon. My name is Seth. I'm the executive director of the San Fernando Valley Bar. It's great to have you here. Before we get started, I just want to thank I want to thank Lawyers Mutual for being our annual sponsor of the association, who in part this program probably wouldn't be possible. So we're grateful to them. And I'll just move right into introductions. We have Erin Joyce with us today as a presenter, and also Amanda Moghaddam. If you've had any sort of passing interest in legal ethics in the last several years, you likely know of Erin Joyce. She's an absolute expert in this area. No less, she has extensive experience in state bar investigations, disciplinary proceedings, including 30 years of civil litigation practice. Erin served as chief trial counsel as a prosecutor for the State Bar of California from 1997 through 2016. Here, Erin has over 25 years of experience handling all aspects of discipline cases against attorneys in state bar court and has personally tried dozens of state bar trials and several appeals. So we're grateful to have Erin with us today. Amanda Moghaddam defends lawyers every day in the claims department at Lawyers Mutual Insurance Company. Prior to her work at Lawyers Mutual, she's represented hospitals and doctors in malpractice suits, and later also represented lawyers in legal malpractice claims at Nemesic and Cole, which is well known in the legal malpractice world. Amanda is the current past president of the San Fernando Valley Bar Association. And if that weren't quite enough, Amanda is also an adjunct professor at the University of West Los Angeles. So I'll leave it at that and pass it over to Erin and Amanda. Thanks for doing this.
Well,
Thanks,
thank you. Let me
Seth.
just share. Let me just share screen. Give me a minute. Okay, I think we appreciate the introduction. And basically, we're here to talk about. I thought this was going to move, but basically, we're here to talk about when the state bar comes calling, what you need to do to avoid problems with basically what you need to know about attorney ethics to defend yourself from any kind of situation where the client will be complaining about your conduct, or either in the context of a complaint to the state bar, or even probably worse, in some kind of civil suit seeking damages against you. Now, for a state bar investigation, the state bar has made it very, very easy to file a complaint. Probably in the, it's almost 10 years ago now, they opened up a portal. And I suggest you go take a look at any of the pages of the state bar website. Every single page has a little button that says, do you have a complaint against an attorney? Do you have a problem with an attorney? Click, click, and that creates a complaint. And it could be almost completely empty as a complaint, but it counts because the state bar is all about the numbers. And guess what? The number of complaints that are received by the state bar's Office of Chief Trial Counsel, which is the investigating and prosecuting arm of the state bar, have gone up in accordance with making it so much easier to bring a complaint in the first place. And so, most complaints probably now come through that portal. And, with your complaint or with the complaint, they can upload, documentary evidence, things like the fee agreement, etc. Most complaints actually come from clients, which I'm sure you're not going to be surprised to find out. But other folks also make complaints against lawyers. Sometimes opposing parties that are unhappy with the lawyer that's quote lying in that ongoing litigation, etc. I would say another big percentage of complaints would be coming from courts when they either, sanctioned a lawyer, or even worse, when they didn't sanction a lawyer, but they didn't want to do a thing, but they still hope that the state bar will do something. So, those are the main sources of client complaints coming through the Office of Intake into the state bar. There are other types of investigations. One big area of additional investigations are what are called reportable actions. And generally speaking, reportable actions are when the financial institution that's maintaining an IOLTA has any insufficient funds activity at all on the account. So even if you have overdraft protection, which the state bar says is appropriate, it's allowed to have overdraft protection on your IOLTA account because it's protecting client money, from potential problems if there's a bounce check. But any insufficient funds activity, even if it's a bank error, has to be reported to the state bar, and it will open an investigation, a reportable action investigation. One other type of reportable action would be a situation when an insurance company like Lawyers and Mutual ends up having, the requisite number of matters or open claims that have to be reported. So they're mandatory reporters under certain circumstances as well, insurance companies. But truly, the vast majority of reportable actions are going to be when it's a bank reportable. Okay, so just to give you the basic life of a state bar investigation, it starts normally with a complaint coming through the portal or by a letter, either by email to the Office of Intake or through the mail. And there is still, there's still some sizable number of complaints that come in through the mail. And what's going to happen is in the Office of Intake, which is a division of the Office of Chief Trial Counsel, there's going to be an initial screening of that complaint with the basic type of complaint, basic allegations, not for the purposes of it, whether or not it's genuine or not, but just what type of case. Because there are certain, I guess you would say, the way that the Office of Chief Trial Counsel is organized, there are silos of teams of investigators with trial counsel, and there are certain types of certain, like, I guess, workflows that are going to be related to the type of case. A perfect example of that is an immigration complaint. So if it's an immigration complaint, it's going to go and be assigned to that team. Again, that initial screening is just like, what type of case is this? Now, there are some really limited number of cases that are coming as complaints that die in intake. That's very, very rare. They want to make everything an investigation because the state bar runs on numbers, and they love to be able to report how many investigations they close. Even those type of, quote, investigations, which used to be routinely handled in intake without a complete full-blown investigation. A perfect example of that is a lot of times clients are antsy to get their file back immediately. And so they'll make a complaint to the bar. Hey, I want my file back. Up until, I don't know, maybe within the last 5 years, those kind of routine complaints were handled within the Office of Intake with just a form letter that would say, hey, we've been contacted by your client. We've closed this inquiry. We've closed this inquiry. It's not an investigation. And if the client reaches out back to us in the next 10 days that you didn't send out the file, then we're going to reopen this inquiry and send it for an investigation. This matters because with respect to what has to be reported by the state bar, there's a qualitative difference between inquiries and investigations. And I'm sure Amanda will talk about the difference for your E&O, whether or not most of the time inquiries, you barely knew about them. Some inquiries literally you never hear about, but an investigation has to be reported. So
I have a question for you, Erin. So I've seen personally more of an uptick in these investigative letters as opposed to just a notification letter like you were talking about on cases, especially in the personal injury arena, where the client might be upset that it's taking too long to get their settlement, but the attorney's negotiating medical liens and the undisputed portion is still not known, right? And there might be a delay for that purpose. Does that fall under that same sort of category where the state bar is just saying, hey, they're reporting a delay, but now they're upping that? Or what have you seen in that in that genre?
Well, actually, my experience is the state bar always wants to get into your trust account. Any excuse at all. If there's a whiff of money, it's going to be an investigation. That is almost never, even under the old system, something that would be handled as an inquiry.
Yeah.
And I'll tell you this, under the current iteration of Rule of Professional Conduct 1.15, which is the safe handling of entrusted funds, this is something that a lot of personal injury lawyers are not getting right. And I can tell you, and it's causing trouble for them. Because just like Amanda said, most of the time, case settled, there's a bunch of medical liens that need to be resolved. And, it just seems to be much more efficient to try to resolve all the medical liens and then do one distribution or one time of distribution. That's not okay anymore. What you have to do as soon as that settlement comes in, first of all, obviously you have your 14 days to notify the client and all the claimants of that receipt. But then you have to do that calculation. Hey, the face value of the medical bills is, like, say, 50,000. The settlement was 150,000. I have a one-third. Let's keep it super easy math for me. So 50,000 attorney's fees. So there's $100,000 left after my attorney's fees, but only $50,000 of med liens and other, liens. That means I need to immediately distribute within 45 days the 50,000 as a partial distribution, and then the disputed funds, which comprise the face value of all those medical liens, you have to work those out, and then you distribute that rest of the funds to the client.
Right.
So in a lot of cases now, you're going to have to do multiple distributions to the client.
Right. Right. Whereas 10 years ago, you might have been able to say, well, it's not certain we're going to do one transaction. I agree. I've seen a huge uptick in this. They're very interested in it.
Yes. And if you're one of the hapless 100 that got selected for the random audits or the compliance reviews that are right now underway, not out of the Office of Chief Trial Counsel, which is the investigative and disciplinary arm of the bar, but instead in the Division of Attorney Regulation, which is where they have the forensic accountants, and they're running CTAP through that division. There, a large part of those compliance reviews will be, hey, on these selected 15 or 10 cases that we've pulled out of your trust account records that you uploaded into the portal, we want to see the fee agreement with the client identified in that settlement. We want to see notice to each one of those claimants to those funds that you notified them of receipt within 14 days. And then we want to see that you distributed the fund money within 45 days or explain the good cause why not. So that's the kind of audits that are being run now. So you have to be able to do this on every case, even without a complaint.
Right. 100%.
All right. So back to this. So then they initially in intake, they'll do that review of the complaint and basically, hey, is this a specialty area like immigration? And then it goes to that team. Otherwise, they're distributed through the other investigation/trial teams. And the Office of Chief Trial Counsel does things lots of different ways over time. As of right now, the latest is, the new becomes old, etc. It looks like the latest way that they're handling it is that unless it's in one of those specialty units, they are now horizontal prosecution, meaning that it's assigned to an investigator, the complaint that came in from a client. It's assigned to an investigator and assigned to a, quote, legal advisor who's a lawyer. And that legal advisor doesn't have a, quote, caseload like a trial caseload. What they're doing is they're just supposedly monitoring and giving legal advice to the investigators during the time it's an investigation. And then I don't even think at the way it's being handled right now that those same lawyers that approve the investigation report, if it's going to move forward, because they also, those legal advisors are supposed to be reviewing the investigation reports, which means it's on its way toward prosecution, or the closing memorandum. Either way, the legal advisor is the one that has to review that work from the investigator. And these investigators have caseloads well over 100 cases, up to maybe almost 150 cases. And under a statutory obligation, a case is considered backlog if it's more than 6 months from the CFR or complaint form receive date. So a large percentage of the investigators' caseloads are already backlogged. So there's a huge pressure to just move this case, push it forward, not work it hard, not get deeply into it, not to have to reach out multiple times for information, as an example. So in order to either close the case with with a closing memorandum or push the case forward with an investigative report, one of the big things that the investigator is doing is having to, if it's a typical complaint, like a client complaint, put together the timeline of the representation. So that always has to be in both of them, either closing memo or an investigative report. That legal advisor reviews that investigative report if it's moving forward and has to approve it. And what that means is that they've approved it and they're supposed to have reviewed the evidence that supports each of the elements of the supposed counts, because that investigative report will say, okay, we have failing to perform with competence, and then all the elements to that, or failing to communicate, whatever it is. And they're supposed to be citing the evidence in the file where, there's evidence of whatever charge there is. And by the lawyer signing it there, they're supposed to be warranting that there's clear and convincing evidence of this.
Mm-hmm.
And why this is important for you to know is because the investigators feel overwhelmed and have high caseloads. The legal advisors same. And the legal advisors, this is in a horizontal prosecution model, they're not even responsible to deal with it after they sign off. So there's not like any penalty necessarily for signing off on something that isn't, fully there. So what they do is they sign off on that investigative report, and then it moves to a hapless trial counsel now that has to figure out how to get the charges drafted and go through the process, which is requesting or allowing the attorney to know, hey, we're moving forward with your case, the notice of intent to file charges letter. And if you're a lawyer that gets that letter, guess what? You have 10 days to both seek the file. If you ask for the file, they're supposed to cough up the file timely, which a lot of lawyers don't do because they don't know that they have that right. And you have to request basically a pre-filing settlement conference, which the court has to set within 15 days. So you're, by a lawyer that's in this process, the bar has taken as much time as they want to get all their ducks in a row. But the first thing you know is you get a notice of intent to file charges letter. And I can tell you, generally speaking, the Office of Chief Trial Counsel by that point is just looking at it as a hoop to jump through so that they can file charges. Because, why? Because they want the stat. As soon as it's filed, it's no longer backlog, because a case is backlog as an investigation until it's either dismissed, closed, or it now becomes a state bar court filing.
Does that apply even if they ultimately decide to dismiss the disciplinary charges?
It doesn't matter because the stat you already got the stat.
Right. So they got the stat. So so are there instances where it gets elevated on the belief that they'll get it off the backlog, but then knowing that they're not going to move forward from that state on so that they get the stat, or we don't know?
I would say this. Remember, if you're the legal advisor that signed off on that investigative report, now that case leaves the investigation stats and now moves into that, legal advisor's, responsibility, their caseload. And what your job is as that legal advisor is to write up the charges and to write up this very complicated document, which is a charging memorandum. So you have to have gone through all the evidence, go through all the case law, and come up with your recommendation for the level of discipline. And that charging memorandum, in the way that the Office of Chief Trial Counsel works, is it goes through a process of like team decision making. I mean, at least one, but maybe two levels above the handling attorney. So all of the problems with the evidence and all of that is completely lost on the people that are going to decide, nope, charge moral turpitude. Nope, this is a disbarment case. So it is dangerous. It is very dangerous as one of the legal advisors to just sign off on an investigative, because then you're like trapped in a box. You're trapped. You can't dismiss. You have no authority to dismiss even a count. And in order to change the level of discipline that was approved by committee, you have to go back to the committee and explain why you got it wrong. That's why the state bar has no problem going to trial and losing, because there's no penalty for that at all.
Interesting.
Now, so once they decide they're going to send out the notice of intent, you can and you should go to the pre-filing settlement conference, because there is a chance there, because you have a neutral judge. They're back to 5 judges. They just appointed them. There was a missing space on the state bar court since last December, but they just appointed a new judge. So you're going to get one of the judges that isn't going to be your trial judge, who can review the evidence and your mitigating evidence too, to let the state bar know, OCTC, what the case may be worth. And so there is an opportunity to settle at the pre-filing settlement conference. So you should always take advantage of that if you can. Okay. So I kind of went over a lot of this, but so I'm going to skip fast this quickly. Basically, anybody can file a complaint for anything, just like in Superior Court, you can file a lawsuit as long as you have your, actually, you don't even need the filing fee. You can get a fee waiver, right? So just because they filed a complaint does not mean it has merit. They make it super easy to do so. I know there's whole programs on the new Rule of Professional Conduct 8.3, but for the purposes of this meeting, there are some situations limited where if a lawyer has credible evidence of either misappropriation or misrepresentation or other deceitful conduct or criminal activity of a lawyer that bears on her overall fitness to practice, you have to file a complaint. And that kind of complaint has to be, if you're doing that, if you have to do that, you have to use the mandatory form on the State Bar Court website. And basically, generally speaking, there's no anonymous complaints. Although I have to say, I've seen some cases go forward where it's weird. They actually have no complainant identified, but that's very much the not normal. Okay, what are the type of complaints that come in? First and foremost, honestly, are communication issues. The lawyer is accused of not responding to phone calls or texts or whatever. And usually the reason why there's a complaint is because there's a billing dispute or some kind of fee dispute. That is a big, big concern. So when you have a large accounts receivable, you're likely to get a lot of bar complaints because clients that don't want to pay their bills like scrutinize your work to try to figure out what you did wrong so they don't have to pay. So the best approach is stay on top of your AR. I heard some of the best advice from an attorney maybe 5 years ago, and I've really tried to take this into my own practice. She said, what you should do is take your whole case list of current clients and grade them based on what you think is valuable to you in a client. Grade them A to F. Payment on time, always return your phone calls, whatever it is, whatever matters to you. And after you grade your clients, go back and look at your time for the last week. And you are going to find, and I found this to be true for me, so I'll suggest you try the same. Your DNF clients take 80% of your time. They will monopolize your time. And who makes bar complaints? Are this grade A clients the ones? I mean, yes, if you stole someone's money, everybody's going to complain. But the kind of like performance type of complaints that is the bread and butter of the State Bar, those kind of complaints come from your D and F clients. You're just not in sync with them for whatever reason. Those are the people to like cut loose with no tears. Because they're the ones that if you don't like them from the beginning, they're not going to grow. They're not going to grow on you. And those are the ones that are going to be your problems later on. And as I already said, most of the complaints come from clients. And if you find someone that has a bunch of complaints against prior lawyers, please don't, push them along and send them to contact one of the lawyer referral services.
But not the San Fernando Valley Bar's ARS. Send them somewhere else.
Right. Send them to LAPBA's, Smart Law,
somewhere
or
else.
something. But don't give them a referral. Don't be responsible for that referral.
Yeah, I agree. Yeah.
So here's what I would say. To avoid legitimate bar complaints, you do not need to know like every single rule by heart. Like, oh my God, rule 1.5.1 or whatever, 7.3 solicitation. You don't need to know that kind of particularity. As a practicing lawyer, if you just always put your client's interests before your own, and remember, you have duties as an officer of the court not to go into misrepresentation, you're never going to have a legitimate bar complaint against you. Why? Because every one of the rules of professional conduct and provisions of the State Bar Act are just different permutations of how a lawyer either put their own interests or the interests of some third party in front of their client's interests to whom they owe a fiduciary duty, or in the interest of zealous, representation, starts either making nonsense arguments to the court or actively making misrepresentations to the court. Now, just in the life of a bar complaint, it takes like up to 60 days just to get the case through that intake process into the hands of a team that's going to be the investigator and legal advisor. And yes, at that point, they're supposed to have 2 weeks to send out the letters. but I have sometimes gotten a letter on a case that has a 24 number. How do you know how old the bar complaint is? Generally, if it has 24-0 dash blah, 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 it came in sometime in 2024. So these are just really guidelines. Some cases are really, really old that the bar hasn't worked for nothing to do with the case, just by who ended up getting it on the wheel that didn't work it or whatever. So in a complaint, basically if a complaint is closed, the Office of Chief Trial Counsel does owe some type of explanation to the complaining witness. And so that's, they'll kind of go through, you alleged this and we found this, or there's not sufficient evidence to show this or that. But the closing letter to the lawyer is just a form letter saying we decided not to proceed. But, you don't want any clarification. You just are happy it's gone, right? That's what I would do.
Yep.
Now, but if they open an investigation, usually the idea is that investigator that's assigned is both going to reach out to the respondent attorney saying, oh, we got this complaint. And unlike other jurisdictions where, like in Florida, they just literally forward the complaint to the lawyer and say, answer this, right? They can't do that in California because the complaint is confidential because it's part of a confidential investigation file. So the investigator has to synthesize or summarize what is the nature of the complaint. And most of the time they do a decent job of that. But sometimes the factual errors in the actual complaint letter you get is because the investigator just muffed it. So if it's an unusual type of situation, like anything related to conflicts, they're not lawyers. They don't know. The complaint came in from a non-lawyer, usually a complaining witness client. So you don't really know why there's problems with that investigation letter, like the facts. But one of the most important things you do in responding to the investigation letter is to provide that timeline of the investigation so that it's really clear what the real facts are and point out the discrepancies with whatever's in the letter, because it might very well have come from the investigator or from the complaining witness. And at that same time, they do ask the complaining witness if they have any additional evidence. And so in a perfect world, that's the extent of the investigation. They get what the lawyer said. They get what the complaining witness added. If it's something where they needed to get court records, they'll go online and get the court records. If it's anything about money, they'll get your trust account records. And they will get your trust account records even at the same time as they send out the letter to you. They do not wait for trust account records anymore, for sure. And if the investigator writes up the case for an investigative report, it goes to that legal advisor attorney who has to approve the investigation. You do not get notified about the investigation being completed until you get that notice of intent letter. So it could be like a year ago, they completed the investigation. They decided they're going to move forward. And now that legal advisor has spent about a year or any length of time getting the charges ready against you, getting their level of discipline approved for their charging memo, and now they're ready to go. Meaning that you have your 10 days to ask for your pre-filing settlement conference. And if it doesn't settle at the pre-filing settlement conference, that's when you're going to have formal charges filed in state bar court. Now, how can you avoid, the case before charges are filed? Basically, sometimes, and it's true, like Amanda said, going to that pre-filing settlement conference can result in, averting charges altogether, especially when a lawyer tried to represent themselves during the investigation process. Sometimes, this is the thing. If you remember back in 2001, they talked about, the FBI didn't connect the dots, whatever. That is not how the state bar works. This is the truth. If the state bar doesn't have, like with a big, thick black Sharpie marker, every single element, they're not going to be able to prove clear and convincing evidence. They aren't. If you have to use the word nuance with respect to the charges against the lawyer, chances are they're not even going to be able to prove them. And wouldn't that be nice if that was enough to stop the state bar from going forward? But it isn't. And there's other reasons for that. So it's really up to you to explain, if your fifth grader could understand why the case should be closed, then you might have been able to convince the investigator. That's what you need to be talking to, a reasonably intelligent fifth grader. Seriously, no legal background. I've had situations where my client just assumed that there was information that the investigator understood that they did not. So it's not a complete lost cause at the pre-filing settlement stage to supplement your response and the factual basis for your position such that it could be dismissed altogether. And that, of course, is a good thing because the state bar, otherwise, if you don't convince them, guess what? They're going to file the charges against you. And what's the booby prize? You might win at the end of the day after a state bar trial. You want that. You want to convince them not to move forward altogether. But if there is misconduct, if there's something that you did that is actionable, it's still valuable to go to the pre-filing settlement conference because then you can hopefully convince them what the real level of discipline is. That would be appropriate because knee jerk out the gate, and I'm sure Amanda would agree, the state bar always is adding moral turpitude to everything, deceitful conduct, which really significantly increases the level of discipline to something that you're not going to want to stipulate to. So you really want to take that opportunity to get them off of that kind of a view of the case so that you can actually resolve it for something that's within the realm of what would be acceptable to you.
Mm-hmm.
Now, if unfortunately you're unsuccessful and they file charges, you are not in a normal court, for sure. The state bar loves to talk about being sui generis. That means they're of their own, if you know Latin. That means they're not quite criminal and not quite civil. You do not want to be learning state bar procedure on the fly. Okay, if you have any criminal law background, you're like, oh, it's up for the criminal defendant to waive, a speedy trial. And there's reasons to do that. I'm not a criminal lawyer, but you understand those concepts. That is not how state bar court works. State bar judges, and never ever call them ALJs because that will not go well. I can tell you that. They're right in the chain directly to the Supreme Court. They do not consider themselves ALJs. But part of their performance guidelines is that a state bar trial is to commence within 125 days of the filing in the review department, in the hearing department. So if it is an ordinary original matter, you have like 4 months from the time that the case is filed. And that initial status conference is going to be about 3 or 4 weeks out. So all they want to talk to you about at the initial status conference is pull out your calendars or set in trial. And it's their performance that's on the line if they can't start that trial within 125 days. Otherwise, they have to establish good cause otherwise. So you can't even, I've actually had situations where even when OCTC and I both approved and stipulated and submitted a declaration to establish good cause for moving the trial, it's been rejected anyways. You're going to be like, what? This is unbelievable. And that is how it is. It's crazy. If you have a DUI, or usually your first DUI is not transmitted, but if you have a second DUI or any kind of criminal conviction, those type of cases, criminal conviction matters, come through the review department, which is the state bar's appellate level, and then they get transmitted. They have to have a trial within 125 days. And it's already eaten up a large part of that time before your initial status conference. So you might have just had an initial status conference, like say this week, and the court's setting trial for December. No joke. That just happened this week. So that is common. So these trials are coming like so fast. So as soon as you know the state bar is coming at you, you need to put your mitigation package together, meaning your evidence of good character, your volunteer work, all of these things which are very difficult to gather and even with very happy and friendly people that want to write you letters, you're not their highest priority. It takes weeks to get character letters, and 1 or 2 is not going to do anything for you. You're going to need 10 or 20 letters. And basically, as soon as it's submitted, the court has 90 days to issue a decision. So these proceedings are very, very fast. I mean, if you're used to normal civil procedure, you're going to be, wow. And yes. And let's imagine your case went the other way and it's closed in investigations, or even closed, once it moves past investigations. There is still a redress that the complaining witness has to go to the complaint review unit. The complaint review unit is actually part of general counsel at the state bar. The state bar has like all these different divisions. So complaint review unit is actually outside of Office of Chief Trial Counsel, and it reviews any decision to close the case. And you have to do that as a complaining witness before you go to the Supreme Court about a closing of an investigation that you wanted pursued. So it does stop a lot of petitions going to the Supreme Court. And this process also takes, 8 months to 12 months just to get a response from the complaint review unit. And what to do if a complaint is filed against you as an attorney. Obviously, never avoid State Bar correspondence. I'll tell you this, up until I think last year was the first year that unless you have ADA accommodations, the State Bar has required every licensee to pay their fees and everything through or access through the State Bar profile. So if you're one of the older attorneys that doesn't do that or hasn't, is not that familiar with your State Bar profile, you should make it a regular routine at least every 30 days to check your State Bar profile, because the State Bar posts these letters on your State Bar profile. And they might send you an email saying, go check your State Bar profile. But if you miss the letters, you're the one that has to be in contact with them, not the other way around. So you do not want to be facing, on top of what else the State Bar might be pursuing, a charge of failing to cooperate with the investigation because you missed the letters. They don't send anything by mail anymore, other than when they file the notice of disciplinary charges, they have to serve it by certified mail at your membership records address. So when you respond to an investigation, make sure about the due date. You can always get at least one extension as a matter of course. I've never seen it denied. And then you really ought to, since they're going to have that timeline of investigation response, how the investigation or the representation proceeded, you should give that to them. Give that to the investigator, even if it seems repetitive, even if it seems like how obvious it is. Don't make them put together the timeline of your representation of that complaining witness. If you put it together, guess what? They might adopt it. That'll help them get that halfway to closing if you do the work for them. So with that, I think I'm turning it over now to Amanda, because we're going to talk about the insurance part of, the horribles here.
Yeah, and I was thinking as Erin was talking, I sort of wish that we had done the program in reverse, but it's actually a good segue as for why. I think that Erin gave you such good advice on the process and what to happen. I want to encourage you all, before you call Erin, if you get a state bar letter, call me first. And that's because your insurance is going to require you to report this to your insurance company, whether you're a lawyer's mutual insured or another insured. That is a potential claim that you are required under your policy to put us on written notice of. Often what happens at that time when you give me a call, we'll talk about the state bar complaint. We'll talk about how to tender it. We'll talk about lawyers who are available to assist you. And then we'll talk about how to respond and what will happen with your coverage if a civil suit were to ever come down the pipe. Just because a state bar complaint from a client is not necessarily covered at the time, when you're just getting a letter that says, please explain your side of the story, right? There's no disciplinary charges filed. At least under our policy, that's not something that immediately triggers the right to counsel and a defense. It's only once there's disciplinary charges that our policy will kick in to provide you up to $50,000 in expense reimbursement for counsel of your choosing. That's how our policy operates. I don't want to talk as to any other policies. Most are similar. They have similar stipends, similar rules. But some policies and some insurance companies are now providing defense counsel from day one from the letter. That is a product that's out there. So if you are in the market for insurance policies and that's something you want, there are policies that sell from the point you get the letter, you get defense counsel to help you with the letter. Our policy is only once there's disciplinary charges filed. But regardless, it's a potential claim you have to put us on written notice of. Failure to do so could have really bad consequences, because if you renew your policy with us and you say, hey, I don't know of any potential claims, and it turns out you've been corresponding with the state bar, and then that client who initially reported you to the the state bar decides to sue you civilly for legal malpractice, you're going to be facing a denial from your insurance carrier, because what they're going to say is you never reported it to us in the appropriate policy period. You have a claims made and reported policy, which I think is on my next slide, and I'll talk a little bit more about. And that means we don't have to cover it. And then you've lost coverage for that civil lawsuit that originally started as a state bar complaint that you never tendered to us. So really big, if you take one thing away from my lecture, let it be that your first call, if you get a letter, should be to your carrier to know what their processes are, so you don't take yourself outside of coverage. So prompt notification, you've got multiple functions, right? You're going to preserve your coverage. It allows us to assess the situation early. If it's a really big problem that you got reported for, we might want to put a defense attorney on the civil side preemptively because we know a claim is coming down the pipes. There might be certain strategic advantages to getting it to your insurance carrier. So don't wait to see if the complaint goes anywhere before notifying your carrier, because like I said, you can lose coverage. Also, we're here to help, right? I can't tell you how many of these calls I take where someone's freaking out about a state bar letter and they leave the phone call going, oh my gosh, I feel so much better. I was so worried about this, right? It might be a big nothing burger, but because we see so many of these, we're sort of able to say, you know what, you need to call Erin Joyce. Versus this looks like it's a slap on the wrist and you're doing okay. So your carrier can provide you with some guidance on that, not nearly as in depth as Erin does, but we do some. And we have dedicated claims professionals who know the state bar system, and they can prioritize how to get you help. Erin, do you mind going to the next slide? Sorry to the viewers, I had some technical difficulties, so I'm going off of my phone. So this is the state bar claims process. So this is obviously different from Erin's presentation of what the state bar looks like internally. This is what it looks like from the carrier's perspective. So the claim comes in. Once you get that state bar complaint, you're tendering it to us during your active policy period. Your notice always has to be in writing for a claim. It's not sufficient to call the carrier and talk about it. It needs to be in writing. The carrier will evaluate whether it's covered or not and at what point it might become covered. They'll explain all that to you. And then if provided, the carrier can manage defense costs and indemnity obligations by appointing counsel. So that's sort of what it looks like from our end. I think we might have skipped over. Can you go back one, Erin? Yes. Okay. I definitely wanted to touch on this because I think most of you should know that your professional liability policy is a claims made and reported policy, but I'm always fascinated by the number of lawyers who don't know this. So if you've been kind of zoning out, now's the time to touch base and listen in because this is really important to be reminded. In order to have coverage under your legal malpractice policy, it's not like an auto policy. I can have Geico in 2019 get in a car accident and go to Progressive the next year. When I get sued for that car accident in 2019, I'm going to tender it to Geico because they were my insurer during the time. Legal malpractice policies are not like that. It's who you have an active policy with at the time that the conduct occurs, okay? That's what it's meant by claims made and reported. The claim has to both be made to us and reported during an active policy period when we insure you. This is why if you've ever had to go up on the open market and you want to change insurance carriers, you have to get what's called prior acts coverage, where they backdate what they're covering for you. And that can quite times be very expensive. And it's why people don't like to move carriers, because with a legal malpractice policy, you have to make sure that your retro date matches up all the way to the present to ensure coverage. So when you get that state bar complaint, you're going to tender it to us immediately. What you're not going to do is renew your policy with us and say, and check the box no that says, I have no knowledge of a claim, because you do. You know that you were reported at the state bar, and that's something on renewal that you need to report to us. Otherwise, your policy can be rescinded for lying to us. Not a situation you want to be in, so don't just do it. You get that letter, you call your carrier first thing. All right, 2 slides forward, I think, Erin. So this is what I was talking about earlier, and I wanted to talk about the nuances of the letter writing phase, which is different than all the technical terms that Erin mentioned. But essentially, before disciplinary charges are in there, and the client has reported you to the state bar, and the state bar is asking for your response. Typical responses include, give us all your bills, give us your retainer agreement, give us all pleadings, right? Show us the work you did on the file, especially in these cases where it's alleged that there isn't good client communication, right? They'll want it all there. That phase where the attorney is writing back and saying, enclosed, please find my relevant file materials, we refer to that internally as the letter writing phase, which doesn't give rise to the state bar coverage that I was talking about, our reimbursement policy. However, we do have in-house claim personnel who are there to look it over, kind of handhold. But if you want a lawyer to represent you, you are coming out of pocket to pay for that if you're a lawyer's mutual insured. And so that's how the policy works. But again, it's still a potential claim, even if the coverage isn't triggered, that you have to report to us. You can go forward to the next slide, Erin. Thank you. All right, so here's the question. Why tender something if it isn't covered? You want to think of that state bar complaint as the first domino in a potential chain of events. While your carrier may not pay for knocking down that first domino, they need to know it's been set in motion so they can prepare for what might follow. You need to give written notice to preserve your coverage, both for whether the state bar is good, you're going to get that reimbursement coverage if they do move forward with disciplinary charges, but also to protect yourself against any legal malpractice claim that might arise in the future arising out of the same underlying facts. And even if it's not covered at that point in time, carrier needs to be aware to monitor developments and step in immediately in the event that a formal malpractice claim materializes. Again, early awareness is strategically valuable in managing your exposure, and we're here to help. So that's the rundown. Next slide, Erin. And I'm going to cruise through these because I want to leave enough time for questions. I know we've got a couple in the chat. We should be on critical elements. Yes, of proper notice. Okay, so how do you give notice to your carrier? Immediately, right? I hope that I've impressed that upon you. So your timing, you don't want to wait for a situation to develop. You don't want to see how it goes. Call us immediately, get it in writing immediately, right? We talked about notice. It has to be in writing. Review your carrier's insurance policy. There's a section on how to report a claim, or if you go to their website, often there's a submission form there. Email may be acceptable depending on your carrier. It is for us. Others might have different protocols. You want to have comprehensive information in your tender, right? A lot of people say, I've been reported to the state bar by a client. Okay, that's enough that's written notice, but who's the client? What kind of case? What went wrong? What went right from your point of view, right? Give us some context so that we know and we get it. Because otherwise, we're just going to call you and bug you for that and ask you a million questions. So you're going to have to end up doing the write up eventually, anyways. Just do it right out of the gate. And then always try to reference your specific policy number and period to make sure that it gets into the system correctly. That's just more ticky tack, but it does help us. Okay, next slide. All right, failing to tender and its consequences. As I discussed, the most devastating consequence could be a complete denial of coverage for any subsequent claim, right? So that client reports you to the state bar first, and then they decide to go get a legal mal lawyer and they sue you. You didn't report the state bar claim to us. You're going to get a denial for that civil lawsuit. And this has been upheld consistently by courts and case law. The carriers have the right to deny coverage based on late notice. And that's because we're in the business of managing risks. We need to know what's going on. We need to know when our insureds are getting reported to the state bar, and failing to send it to us can you to lose lots in coverage, meaning no indemnity for settlements. If that client sues you for civil legal malpractice and it's a case you could have gotten rid of for $50,000, that probably would be a pretty easy decision for your carrier because we're going to spend $50,000 trying to get it through summary judgment, right? We might have been able to settle that for you, but if you have no coverage, that 50,000 is on you, and that's no fun, right? Wouldn't you rather the company that you've been paying premiums into, they should be paying that out on your behalf. So definitely not worth it. Your personal assets could become exposed. And nobody wants to be sitting close to retirement with somebody threatening to take their house over, over something that could have been avoided if you just tendered it to us. But beyond that coverage denial, late notification creates additional problems that can affect claim outcomes and your professional reputation. It gives us missed opportunities for early investigation and witness interviews. You're losing out on the expertise of our panel and the lawyers we work with. This is all they do day in, day out. So while you might think you know how to best defend it, you might go, oh, this legal malpractice claim is time barred. I guarantee you my panel lawyers can do a better job getting it kicked out than you can. And that's not, saying anything about your caliber of practicing. It's just to say that that's all these guys do. So why not have the experts do it when you've already paid into it with your premiums? And then there's the increased personal stress and financial burden. I can't tell you how many insureds have called the company and they're like, I know I messed up. I've been self-defending for a year. This pro per litigant won't go away. I have cancer. I can't focus on it. I need a defense lawyer to step in. And that poor lawyer who decided to defend themselves to possibly save a buck on underwriting or whatever the reason was, they're going to get told no. And I just think it's not worth it to ever be back in that position where you're stuck defending a case against yourself when you could have had coverage for it. Okay, so next slide.
Here it is.
Okay. All right, so triggers for state bar reimbursement and how it works. Most policies are going to give you a specific dollar amount of how much you can get reimbursed for hiring someone who does the work like Erin does. But they range from 25,000 to 75,000. As I said, our policy is 50,000 in reimbursement coverage for reasonable fees and costs incurred defending state bar disciplinary charges. It covers costs for expert assistance should that be needed, expenses related to gathering and producing responsive documents. It does not cover if you are ordered to pay restitution. This supplemental coverage will not cover that. That's on you. It does not cover lost business opportunities or other monetary impacts of license suspension. Okay. So there's not going to, if you get suspended for 60 days, you can't make a claim to your carrier that says, hey, I would have earned 50,000 during these 2 months, but I wasn't able to practice law. That's on you. That's your loss. Okay. All of this gets covered as long as there's a timely report made to the carrier. It's usually counsel of your choosing. Some carriers may differ on that. We allow you to choose whoever you want to defend you before the state bar. Reimbursement does mean you have to pay it up front and then submit an invoice for proof of payment. So in this, it's not like a regular claim where I just pay defense counsel's bills. This is actually on my insured to get me both an invoice and a receipt, and then I reimburse them. So on one of these, say my insured hired Erin, Erin isn't billing me directly. She's billing the person who got named in the state bar complaint. They're paying it, then they submit it to me for reimbursement. Sometimes that's problematic for people who don't have a lot of cash on hand. I will say I keep that in mind and try to reimburse very, very quickly within days of receiving a request. That's how the process works. And you should know that the $50,000 expense reimbursement for state bar coverage is kind of its own world, separate and apart from the rest of the policy. So it has nothing to do with your burning limits on your insurance coverage. So say you have $1 million policy, right? That is a burning limits policy. So defense fees and costs come out of that limit to pay for your defense in a civil lawsuit. That isn't affected by the state bar coverage. So in other words, if an insured paid 50,000 to defend themselves before the state bar and then they get sued civilly, that 50 isn't coming out of their $1 million limit. It's separate and apart from it. Just a nuanced point, but I think it's important to know how your coverage works. Okay, next slide, please. What is it? Common misconceptions and mistake. The biggest one, I'll wait and see if the state bar forwards the complaint for investigation before I report it. Big no-no. I hope I've explained that to you why. Or people who say the complaint is clearly frivolous, so I don't need to involve my carrier. Wrong. Most of the lawsuits I see, civil lawsuits, are frivolous against attorneys, right? Lots of people get mad after the divorce and they decide that they're still mad at their spouse, but they've settled with their spouse. So let's go after the family law lawyer, right? Just because it's frivolous doesn't mean don't report it. I verbally told my broker about the complaint, so I'm covered. No, we've talked about how notice needs to be in writing. So those are your three big pitfalls that I see where people end up getting denied when they shouldn't have. Okay, last slide that's substantive. Protecting your practice, state bar defense action plan. So what we talked about, we're going to immediately report it and evaluate whether we need a lawyer, draft comprehensive written notice to the carrier, and communicate with the investigator if you need an extension of time to respond. I don't remember, Erin, did you talk about extensions of time to respond to in the letter writing phase in your presentation? I don't know that you did, but my experience has been if you ask for a 2-week extension, it's almost always given, right?
Yeah. In fact, when I step on a case, even if there's been a prior extension, for the attorney, I always ask for
Mhm.
30 days from the deadline, and I've never been denied. So
Okay, well,
this,
maybe I'll start telling people to ask for 30 days instead of 2 weeks. I learned
yeah,
something today.
yeah, you can ask for 30 days. And
Okay.
generally speaking, this is supposed to be a fact finding
Mhm.
situation. So they don't have a window that closes. In order to get
Mm,
a violation of failing to cooperate with the state bar, there's multiple efforts to get your response.
right. You ignored them for a long time, right?
Yeah, it's much, much, much better to
Interesting.
provide a full and complete response than to do not dribble information to the investigator. They
Yeah.
don't want to test their file multiple times.
Well,
So
and they've got too much on their plate. That could end up being detrimental to you, right? Because they're not going to necessarily remember the first round of dribble.
it's annoying. And the last thing you want to do is annoy,
Yeah,
honestly, right? You want to
so
make it
true.
like easy, easy, easy.
Yes,
Because if it's not easy, then it's going forward. Unlike almost
100%.
anywhere else you've been, if you don't convince them why to close the case, it's easier in their process to move it forward than to close it.
Mm,
It's
such
up
a
to
good
you to
point.
make it easy. So I
Yeah.
think we have like just a few minutes if there's any questions or
Yeah, I saw a couple in the chat. Let's see.
There's
We've got,
two.
yeah, go for it.
Is the state bar court in Los Angeles, or do you have to go to Sacramento?
okay, the state bar is not in Sacramento. There's an office in then they used to own the building until really recently in San Francisco and in Los Angeles. They're the um, Smart and Final building. So there's the two courts. But one of the best things that COVID did is it moved all state bar proceedings except for trials onto Zoom. So
Mm,
most lawyers never have to go into the state bar building or the state bar court. They've spent millions and millions of dollars retrofitting.
Great. And we have one more question about if there is an insurance settlement of a timely reported claim, will policy renewal be denied by the insurance company? And under what circumstances will the policy be renewed?
ooh, so that's an underwriting question. It's kind of out of my wheelhouse. I can tell you my rudimentary understanding of how it works, which should be taken with a grain of salt because I am not an underwriter. Most companies look at this as dollars in, dollars out. So if you've been with an insurance company for 30 years, paying a $5,000 premium every year, you've been a pretty profitable insured with that one-time settlement that we had to pay out. If it exceeds what you've paid into the company over the years, you're probably looking at a jump in rates. Where we talk about non-renewal is typically with earlier policyholders who haven't paid in a lot, who have shown to be a bad risk, right? They might have had two claims in a policy period, and we're just starting to think that they're a loose cannon and that they're a bad risk. that's when non-renewal is talked about. I don't see it often with seasoned practitioners who are good lawyers who just had a bad run, got a bad client. Maybe they should have declined, but they took them on anyways. Those sorts of cases, even if they end up being expensive, generally they're not going to talk about non-renewing in that circumstances, but you may see a rate increase.
Terrific. And with that, I think we're at the end of our hour. This was so valuable and so pertinent to everybody on this Zoom. Thank you both, Erin and Amanda. Wealth of knowledge. We so appreciate it. And we
Yeah,
will get out the
anytime.
MCLE slips later today. Thank you all.
Thank you,
Thank you.
Linda.